More post office scandal for you, and yet more lawyers behaving badly, or at least inappropriately, in my opinion, of course. I'm quite surprised about this one because this is something that happened back in January, and I was expecting it to sort of be bigger news than it is. But nothing's happened, so I thought I'd just introduce you to it and see what you think. I'll be interested in your comments. So what am I talking about? I'm talking about a couple of letters which I have here. And I'm doing this one indoors today because A, trying to read these letters on a blustery cliff top just didn't work. And also, for newer viewers, you've probably not met Lord Loverduck and Cappy Barrister yet. And they were feeling like left out because they hadn't done a video for a while. So here we go. But what letter am I talking about? I am talking about this letter. Okay? Now, this is a letter from Nick Reed, the Chief Executive of Post Office Limited, to the Right Honourable Alex Chalk, King's Counsel Member of Parliament, who of course is the Lord Chancellor and Secretary of State for Justice. And this was about how they're going to proceed, with putting things right. So, as he says, as you give urgent consideration to the question as to whether and how the process for appeals against convictions flowing from the Horizon IT scandal can be accelerated, you should be in no doubt of today's Post Office's determination to ensure the proper redress is achieved for all those affected. So very strong words, very good. But then he makes reference to a letter. And he says, in the meantime, I attach a note prepared by Peters and Peters, which covers this and other issues you may find helpful in your deliberation. So who are Peters and Peters? Peters and Peters was one of the legal firms acting on behalf of the Post Office at the time. Sorry about all the rustling here. But I like to do this live and real time and unrehearsed. So this was a letter. Now, interestingly, it came from somebody called Nick Vamos, who is the partner and head of business crime. And the way he signs off this is going to be relevant, so I'll hold that up for you as well, and hopefully you can see that. Note, for and on behalf of Peters Solicitors, LLP. So what does he suggest and say as to how this should be remedied? Well, he has some very strong thoughts. One paragraph particularly. The most significant issue is that all the HCAB recommendations, that's the House of Commons committee dealing with this, and the recent media and political response is based on the false assumption that there are 700 wrongful convictions. Therefore, there are hundreds of miscarriages of justice still out there whose route to justice is somehow being thwarted by Post Office Limited and, quotes, the system. In reality, it is highly likely that the vast majority of people who have not yet appealed were in fact guilty as charged and safely convicted. He goes on, unless this is made clear to the government, it risks making incredibly important and expensive decisions on a completely false premise. In other words, if you're going to compensate these people, I think they're all guilty. So if you have this blanket pardon, and I've discussed before why I personally think this is a bad idea. I mean, I can understand why there's a need for urgency and people are pressing. But I do subscribe to the idea that these people were convicted in a court of law and they deserve to have a court of law completely exonerate them. If it's just done by legislation, effectively a bill of attainder, the problem there is, and we've already seen this narrative being pushed, oh yes, well, all the guilty ones will benefit as well, but hey, it's better that, one guilty person goes free than one innocent person gets convicted, which is actually, a principle of common law systems generally. We always say this. My lord, it is better that 100 people go free, guilty people go free, than one innocent person is convicted. My client is guilty, let him go free. But what you're seeing now is a sort of a narrative that, well, look, we're just going to pay out, but it's all because of the publicity and social media. There's no real merit to all this. And this is the problem because, as we've discussed before, if it's a blanket pardon, if people go for DBS checks, it's going to show up. If people apply for a visa to go to a particular country, they're not going to be interested in, oh, well, actually, here's the full history of the miscarriage. They're just going to go, I'm sorry, you're convicted, and all there is here is a thing saying you are pardoned. Now, another problem with pardons is, it's generally been believed that pardons you have to accept your guilt. You have to actually accept a pardon, arguably, because a pardon has always been what we call a deed. And a deed is a special type of contract. But a pardon has to be executed. You can be offered a pardon, but you don't have to accept it. You have to actively take steps to accept it. Now, this has thrown up issues in the past because in the US, they've done blanket pardons for people who, like, dodged the draft in Vietnam. And they've said, oh, everybody's there is innocent. They've done blanket pardons on certain sort of, like, low-level drugs convictions. So the argument is that actually, yes, this is all very gestural, but you actually have to accept them, and you have to accept you are guilty. Because a pardon isn't saying you were wrongly convicted. It's saying either you were unfairly convicted or times have moved on. It's like the Alan Turing pardon. I mean, at the time, that was the law. People have recognised that it was a bad law and an unfair law, and Turing was despicably treated, especially after all he did for us in the war. But the fact is he was convicted. Correctly. So that's why they went down the pardon route rather than the appeal. I mean, you can actually have posthumous appeals. That's what happened to Derek Bentley. He had an appeal decades after he'd been wrongfully hanged, and he was successful on that. But I'll just go on for another paragraph from Mr. Vamos, because he addresses this point about the Court of Appeal. And he says, the fourth issue is the unspoken assumption that the CACD, that's the Court of Appeal Criminal Division, which is actually its correct title, would overturn more convictions if only POL would let it, or it considered different arguments or evidence. In other words, what he's saying is, because in a lot of these appeals, the Post Office said we won't contest the appeal. I mean, theoretically, the court can still not grant it, but generally speaking, if you say we're not going to contest this, then the appeal will be allowed. But it goes on. There is no basis for thinking that the CACD will depart from Hamilton. Hamilton is a particular case that deals with how what the test is for an appeal. I mean, it used to be that the test was that you had to show the conviction was unsafe or unsatisfactory. They got rid of the unsatisfactory limb of that, so now you have to show that a conviction is unsafe. Some people argued it makes no difference. Some of us were saying, well, no, because you can have a conviction that, yes, you've convicted a guilty person correctly, but you've done it through, inadmissible evidence or fake evidence or false evidence or, abuses or, fake confessions or tortured confessions or something like that. So we're saying, the unsatisfactory test put the emphasis on the state to prosecute people properly. Although there's always been this idea from the Court of Appeal that allowing appeals, and indeed things like excluding evidence, that's not there to punish wrongdoing on behalf of the investigators, because fundamentally there is a public interest in having a trial and convicting guilty people just as much as there is of acquitting innocent people. So, this is all getting into what we call jurisprudence, the philosophy of law. But Mr. Vamos goes on, because, there's this argument about, well, what happened with people being bullied and effectively blackmailed into, if you don't confess to this, then we'll prosecute you for the more serious offence. We'll prosecute you for theft rather than false accounting and things like that, and you'll go to prison for longer. The recommendations assume that only psychological barriers are preventing hundreds of PFAs from appealing, that's, postmasters, and that if those PFAs came forward, then given the proper evidence, the Court of Appeal would allow the appeals. However, this, quotes, trauma theory only works if hundreds of innocent PFAs, and he's actually underlined this, made false confessions. Even if that is true, which is very doubtful because the burden is on the applicant, the Court of Appeal will expect them to give evidence on oath to that effect, and it can then consider in reaching its decision. No one has been prevented from doing that in any appeal to date. Several have withdrawn their appeals when it became clear that this is what they needed to do. The government can't change the basic principles and procedures in the Court of Appeal. If a postmaster was convicted based on false confessions and in fact suffered unexplained shortfalls, then at some point they are going to need to explain that to a court. So he's very much putting the burden back on the postmasters. But what was the fallout from that? Because first of all, it makes you wonder if the Post Office chair had actually read that letter. because he just sort of, it's the last line of his letter going, oh, here's a note that I've asked the lawyers to prepare. Because now, obviously, he's backpedaling from that. He's going, oh, no. And he's made statements since saying, we totally disagree with that. We totally disagree with that. And Mr. Vermos has said, no, I was only speaking in a personal capacity, not on behalf of the firm. But, we've seen that he's signed it off, for and on behalf of the firm. So there seems to be some backpedaling there, both from Mr. Vermos perhaps realising that what he's saying is not exactly going down well, with the current public mood, but also for Mr. Reed, the post office chap, saying, oh, no, we totally disassociate ourselves from this. But like I said, this is just an example, perhaps, of the mindset. And we've seen that with a lot of people giving evidence in the inquiry where they've said, we are convinced, a lot of people saying we were convinced they were guilty and all the evidence pointed to it, so stop picking on us for doing our job. But some people are maintaining that. There was that woman the other week who was going, I still think they all did it. Despite being faced with lots of evidence suggesting that it was clear. I mean, one thing we've seen in the post office inquiry, a common theme is, I was completely out of my depth. I didn't know what I was doing. You can't blame me. I was just doing what the lawyers told me, and the lawyers are saying we were just going with our client's instructions. I mean, everybody's failed at their jobs. Janelle Singh, I think Mr. Beer, who's been cross-examining on behalf of the victims, it's a model of good advocacy. But one question I would like to see put, although I can see why they've not risked it, because this is an inquiry in front of, a professional judge. So you don't really try the jury tricks. I mean, I used to do that, and sometimes judges go, Mr. Robertshaw, I'm not a jury. But I think a legit question is, what exactly were you being paid for then? What benefit did you provide to the post office? Because we've had people saying, I just signed letters and legal documents that were put in front of me. I've got no idea what they said or what they did, and nothing in there was down to me. So I just signed these. We've had other people going, I just did what the lawyers told me. So I was basically just relaying on all their information. So I think a legit question would be, what's your salary? Okay. What's the benefits to the post office for paying you that salary? What exactly do you do? But yeah, I mean, there's a lot of criticism of lawyers here. Now, Joshua Rosenberg, who obviously is infinitely smarter than me, he does, I subscribe to his Substack thing. If I want to get some facts right, I always go check with Joshua. But he did a thing on Law in Action the other day, talking about what's likely to happen to lawyers. I mean, I've been watching what the SRA are doing and what the BSB are doing. The SRA have said, we're not going to take any action at this time, because the purpose of regulation isn't just to punish wrongdoing lawyers. The idea is that they start from protecting the interests of the public. And what they're saying is there's nothing to suggest at the moment that the public are being put at risk by these lawyers. Because, if people are bad, then they can say, we're going to suspend your practicing certificate until we resolve this. Because we're not saying you did do anything wrong, but we take a precautionary approach. If there is a hint that you are a danger to the public, it's a privilege being allowed to practice law, and we can suspend that privilege pending you proving that you're safe. But personally, things I've spotted, clearly, poor old Warwick, the barrister, I mean, he has clearly failed in his duties regarding disclosure, which he has admitted in the proceedings. He's now said, yes, I got that all wrong. But the question is, I mean, I was trying my incompetent best to defence? Well, it's certainly not in terms of professional negligence. But have they overstepped the mark? Might we see prosecutions here for conspiracy to pervert the course of justice or attempts to pervert the course of justice? And I think there is a prima facie case here. I mean, the mere fact that they may have honestly believed that these people were all guilty, that's no doubt what their defence will be. We thought these people were guilty, or at least there was a case to answer, and we just put the evidence together the best we could. But there's been so many failings in terms of disclosure, how the evidence was presented. I mean, I also think some of the cross-examination of witnesses was quite brutal, but in the post office cases. But, they're within the remit of, counsel's discretion. I mean, I'm a very sort of gentle cross-examiner. I always explain, because, I do lots of the advocacy training for the new barristers. And I always say it's cross-examination, it's not examining crossly. So even though we always say, use your own style, we're not trying to create clones, I do point out that you can get quite far with cross-examination if you go softly and take a gentle approach to it. Especially when it's not actually one of the parties you're cross-examining, it's just one of their witnesses. You can appeal and say, look, you're a reasonable person. What about if I put this to you, what might you think about that? And sometimes if you're nice to people, they will give you the helpful answers. But yeah, I mean, in this particular case, I think there are certainly people have failed in their core duties just as lawyers. So there's certainly disciplinary aspect to that. It'll be very interesting to see what happens. But I do think that not just the lawyers, but certain people in the post office, I think arguably there is very much a prima facie case to investigate whether there has been a conspiracy to pervert the course of justice here. And if not to convict innocent people, to rig the evidence to effectively, as TV tropes put it, frame the guilty party. So, noble cause corruption, they used to call it back in the day in the police, where, yes, we know we're bending all the rules and we're cheating and we're, not giving somebody a fair trial, but it doesn't matter because they did it anyway. So there you go. I'll keep following this and see if anything comes of it. Because like I say, this letter was sent in January the 9th. It was released came to public attention about 6 weeks later. And all the lawyers have been chatting about it, but haven't seen particularly anything in the mainstream press about it. So I just thought you might like to know. So there you go. As always, hope you found that vaguely useful, vaguely interesting. I'll try and get out and about for another video at some stage. But this one... I just needed to be able to read the letter without it blowing away on a cliff top somewhere. And also, like I say, Cappy Barrister and Lord Loverduck would like to meet you. So there you go.